So here they are, the two of them. That is Ludig and Tribe, a washed-up former Harvard law professor. You guys are smart. You're here for a reason, as am I, to defend liberty and to advance the cause of Americanism. So it's worth a little bit to listen to them so I can obliterate them. So here we have some so-called legal experts. We have an old, retired federal appellate court judge, Michael Ludig, who I know quite well and want nothing to do with. When I was about 20 years old and in law school, I was an intern for the Chief Justice of the United States. Not a clerk, because I hadn't graduated law school yet. I was an intern. And he only had one intern every summer. And I applied, and out of all the people who applied, I was accepted. Believe that? And his clerk at the time was a gentleman by the name of Michael Ludig. And Michael Ludig actually clerked for 2 years because the Chief Justice Berger and Ludig were very, very tight, almost a father-son relationship. And Mike and I were pretty tight too, I would say very tight. And over the decades, we maintained our friendship. I mean, we weren't socializing all the time, but as a matter of fact, very rarely. But he became a federal appellate judge. After that, he became general counsel, I think, for Boeing, maybe. And I had advocated him for a period of time with one Republican administration, I don't remember which one, to be on the Supreme Court. That's how smart I thought he was and so forth. Then I watched him during the January 6th committee hearings, and I said, this guy's unhinged. I don't know this guy. He's lost it completely. Not only has he lost a step or 10, I don't want to say what I'm thinking. He's just way, way off. So here they are, the two of them. That is Ludig and Tribe, a washed-up former Harvard law professor, who's the guy the Democrats and the left turn to when they want to get an opinion that they want. And he's always trashing Dershowitz. He was a colleague at Dershowitz some years ago. I think they're both in their 80s. I know Dershowitz, believe it or not, is like 84 years old. Does he seem 84 to you? Man, hope I'm not sharp at 84. But Tribe has, he's deteriorated. Nonetheless, these two knuckleheads, they wrote a piece in The Atlantic, which is a left-wing publication, talking about how the 14th Amendment, Section 3, provides that Donald Trump literally can be prevented from running for president, can be left off of a state ballot if a state attorney general or a state secretary of state or a state legislature decides that he can, because of the 14th Amendment, Civil War Amendment in Section 3. I'm going to let you hear what they say, and then I'm going to respond to them when they're done. Now, I have to tell you, it's a little monotonous. The subject matter isn't, but they are. So stick with me. You guys are smart. You're here for a reason, as am I, to defend liberty and to advance the cause of Americanism. So it's worth a little bit to listen to them so I can obliterate them. Go.
In a new piece in The Atlantic, constitutional scholars Lawrence Tribe and former Judge Michael Ludig.
Let me just say right here, Ludig was so boring that we decided just to go with Tribe, who's boring enough. So I wanted to just clarify that. Go.
Write this, quote, the former president's efforts to overturn the 2020 presidential election and the resulting attack on the U.S. Capitol place him squarely within the ambit of the Constitution's disqualification clause, and he is therefore ineligible to serve as president ever again. And Professor Lawrence Tribe and Judge J. Michael Ludig join me now to talk about this. Gentlemen, it's a real honor to have you both on at the same time. Thanks so much for doing this. Your argument, just to explain this to our viewers, essentially comes down to these two sentences in the Constitution's 14th Amendment. No person shall be a senator or representative in Congress or elector of president and vice president who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Professor Tribe, an honor to have you on as well. Does that mean that Trump is essentially right now automatically disqualified, that he shouldn't be allowed on ballots and so on?
Jim, what it means, and it's a great honor to be on with the distinguished and justly celebrated Judge Ludwig.
Celebrated where? I'm just saying. Of course, these guys used to hate each other's guts, but this is what they come together on. Go ahead.
What it means is that secretaries of state or other officials who are responsible for deciding who is qualified and who is not will have to determine whether, despite his obvious attempt to overturn the 2020 election and engage in insurrection, whether despite that, somehow Trump gets to run. Secretaries of state around the country are going to go both ways on that. The red ones may go one way and the blue another, although I would hope that partisan politics wouldn't always determine it. But whichever way they go, they'll be challenged in court. And that'll end up in the Supreme Court. And what it will have to decide is what this language means. It's pretty obvious what it says. In fact, when it was written, Abraham Lincoln was no longer president. We had a president who didn't believe in the 14th Amendment, Andrew Jackson.
Excuse me. It's Andrew Johnson. He was the vice president who became president after the assassination of Lincoln. Andrew Jackson was president of the 1820s. I told you these guys are not, they're just, go ahead.
They weren't going to rely on him and his Justice Department to decide who should be convicted.
There was no Justice Department until 1870. The amendment was ratified in 1868. I'm just listening to this. Go ahead.
Of insurrection, that's beside the point. So it's important to see what happens in all of these 91 pending charges of crime against the former president. But whatever happens in those cases, this disqualification, like the disqualification of someone who was not a natural born citizen, or the disqualification.
That's a totally different provision of the Constitution, having nothing to do with the 3 post-Civil War constitutional amendments. Nothing. Which is why it took 2 other eggheads, 125 pages in a law review article, to explain to us why the word president is in that language they read, yet it's not in that language. More later. Go ahead.
Qualification of someone who doesn't meet the age limits has got to be enforced according to its terms. For a very long time, Americans didn't take this seriously. But now that scholars have begun to look at it, and as the judge says, I've looked at it for a long time, it's impossible to disregard.
By the way, just so you understand, folks, there are more scholars who say no to this than say yes. But the ones who say yes, obviously, are promoted by the Jim Acostas and the media.
Want to see more? Sign up for Levin TV.